As Billy mentioned, my name's Craig Foor. I know some of you on the Zoom, but I don't know quite a few of you. I am one of the financial planners here at Everence Financial, based out of gloomy northern Indiana, fall day today. I've been with Everence, I've been in the industry almost 26 years and been with Everence for about 21 of those. And this is one of my favorite presentations or discussion topics that we have because A, most people are pretty interested in it, and B, it's a decision that a lot of people put off, or there's a lot of misconceptions out there too. So, my goal today is really that you would be able to take a couple key ideas, topics, thoughts from this presentation and be able to incorporate them in your own financial decisions while having a little bit of fun and learning a little bit about kind of who we are as an organization along the way. The RCA and Everence have partnered together. I think we did our first pastor financial plan in like 2020, Billy. So you could correct me if I'm wrong, but we've had a really, really good partnership because the two organizations have a ton of similarities on their mission and the type of impact that they want to make in the world. So it's been a great partnership for sure. So with that being said, that's kind of the ground rules. If you have questions, you can either use the chat, and I'm sure Billy will monitor that and ask those after the presentation, or we can just kind of open it up at that point as well. So let's jump in. Um, You may or may not be familiar with kind of who Everence is. Everence is an organization, as I mentioned, that's based out of Goshen, Indiana, which is here in northern Indiana. We have offices in about 16 different states, however, so we work with folks of similar faith values all across the country. We started as Mennonite Mutual Aid back in 1945. We rebranded to Everence back in 2010 for a few different reasons. Number one, if you Google, we went by MMA. If you Google MMA, you actually get mixed martial arts boxing as the first topic that comes up, which was way different than the kind of vibe we were trying to put on from a faith-based organization. Really, primarily, the second reason we rebranded to Everence in 2010 was the fact that you thought you had to be Mennonite to work with us. And the reality is, a lot of our largest growing denominations, including the RCA that we work with, are not Mennonite. And so it's been really, really good for our organization and a lot of people across the country that didn't really know we were out there. You can see there we're based off of principles of Christian stewardship. We do have, we were one of the leaders on the social responsible mutual fund or social responsible investing side, which started for us in 1994. So it's something we're kind of proud of. We're pretty proud of the fact that we're one of the leaders in the industry on screening out and social advocacy with your investment dollars. And so we have some really, really fun stories regarding the social responsible side. You can see we're a little bit bigger than you would think we would be for a small little outfit out of Goshen, Indiana. We just passed 8 billion assets for our members, and that actually is, if you look back 15 years, we were at 2 billion. So we've had some pretty good growth over that last time. Um, One of the things we'll talk a little bit about it. I won't touch a ton on it today, but for most of you on the call, philanthropy or charitable giving is something that is important when it comes into your estate plan. And so one of the things that I want to just kind of, and I know the RCA has some things there as well. Um, we do when we're talking about charitable giving today, that's something that's near and dear to our hearts. And it's something that I just show you this slide to say that, one of the things that is important when you're looking at through an estate plan is what impact does charity have when it comes to your estate plan. And so you can see I'll really just highlight the last bullet point there. Members are giving and people are giving through their estate. We distributed over $100 million to charities across the country in 2024 by using some of the strategies that we're going to talk about today. I always joke when I'm doing these presentations that friends don't let friends give cash. And because there's so many different creative ways of giving, we could talk another hour just about creative ways of giving. But I tell you that kind of comes into play here when we're talking about these things. What is our goal in today's message and also our goal as an organization? Well, we use an acronym called ACE. And it really goes down to three different things. We want to align your goals and your life mission with your financial decisions so that we can give you confidence that you're going to be okay in your financial future. And once we do that, that confidence really empowers members to give their time, talents, and resources, not just to organizations, but to the people, causes, and organizations you care about. And so, at the end of the day, if we're going through financial planning or we're talking about something like estate planning, if we can answer those three ideas, those three concepts, so that we can empower you to give your time, talent, and resources to those different places, I feel like we're on the way to kind of doing God's work and using the resources in the way that God intended us to. Now, where does estate planning come through all of this? So you can see this is something that we use as an illustration with a lot of folks on kind of this. If you look at the Certified Financial Planning Board, what is the six areas of financial planning? And you can see they're ones that you would normally think of, things like cash flow planning, protection planning, investment planning. Retirement planning is the fun one that most people are really interested. Tax planning, and then estate planning. Everence, we also think that there's another important one there, and that's that charitable planning piece. And so we think of it as seven branches of financial planning. So we're going to talk about those last two with the focus on the estate planning side today and what does that look like. Now, one key note, all of these things are intermingled. Okay. So if we can talk about estate planning a lot and really zero in on that, but if the retirement planning isn't correct, or we haven't talked about protection planning, all of those things come into play to create an estate plan. So if you haven't reviewed those things, we would definitely recommend that you review them with us, with someone that is a financial planner that can help look at the whole picture to make sure the estate planning really fits into where everything else is going. So let's dive into an estate plan, talking about estate plan. Now, most people, when they think of an estate plan, they think of their will. That's the most common thing that comes up. There was a study done in 2019, so it's a little bit dated, but it was one that caring.com, which is kind of an elder organization, came out and they did a poll that said, do you have a will? And 76% of adults said having a will is important. And you can see the percentage on the right-hand side of folks with a will. It goes up, obviously, as folks get older. One of the key notes there is that only 40% actually have one. And it gets even lower if you look and say, do they have the right one? And do they have the right wishes within that will? I use the example that one of my best friends from college has five girls right now, and he's still, I literally really want to drag him to an attorney's office to get a will done. It's not for the assets. It's for what happens if something happens to him and his wife, and we don't want the state of Indiana deciding who takes over his kids. So there's a lot of different reasons for a will, and it's not always the financial piece, it's those other aspects as well. And I always joke here, your plan is outdated when there's no reference to your kids and you have two teenagers. I won't have you raise hands, but how many of you have one that's old enough that it could actually legally drive a car? Um, and you can't remember the attorney, or the attorney is actually retired by now from the drawing up of your estate plan or your will. At the end of the day, what are the reasons to plan? Well, there's really, five that I have listed here. These are the five most common things that we want to take a look at when we're looking at an estate plan generally. Number one, who are going to be the beneficiaries? Who do we want to receive the assets that God has entrusted with us, that we may have left when He takes us home? And so that could be things like Kids, children are the most common. Nieces, nephews, other heirs, other brothers, sisters. It could be something like beneficiaries as far as charitable beneficiaries. And there's strategies that you can employ there as well. That's one of the number one reasons that people make a will. The second is to name an estate executor, or if you have a trust, and we'll talk about trust a little bit later, who should be the ones that come in and take over and do the legwork behind making sure the will or the trust is executed. Okay. So that's another conversation that typically needs to be had, and it's not always an easy one. For folks that have children, I have three daughters. For folks that are still in the house, for folks that have children, this is the most common hang up in doing a will. That's why I can't get my best friend to go do a will. It's not because he has a bunch of money, it's because they can't come to an agreement on who would be the guardian of your children. The fourth reason to make a plan is medical and financial decision makers. So things like healthcare power of attorneys and durable power attorneys, creating those documents to make sure that our wishes are known as well. And then finally, to do charitable intent. It's a way to, if we want to give to charities through our estate plan, it's finding out the most efficient and the most proper ways to do that as well. So what are the steps in the planning process? We're ready to go. We want to start this process. The first two are actually the most difficult, and the first two are where most people get hung up on. The first one is talk about it and meditate about it, figuring out what do we want to have happen here. A lot of times, life goes on, we're working, we're retiring. It's not in the back of our mind. It's not a fun conversation either. So really talk about it and meditate it, figure out what those wishes should be. And that kind of goes along with discerning. Discerning, where do we want our assets to go? How much is too much for our kids or for charity or for any specific person? The third one is develop and implement the plan. One of the largest misconceptions when it comes to estate planning, and one of the topics that I hope you take away with you, 90% of this stuff you can do on your own. We always think that there's an attorney that needs to do everything for our estate plan. And we'll talk about key ways that you can make these changes or these decisions or utilize these documents and these plans on your own. So the develop and implement step usually isn't as difficult as most people think it is. And then finally, review it. We say review it every 3 to 5 years. Is that's Most people don't do that. Review it every 3 to 5 years. Most people just do it on life-changing events, births, deaths, those types of things. But it is still important because tax laws change, rules change, state laws change, and so we want to make sure that it's the most up to date as possible. You're going to want to identify a good team. So, as I mentioned kind of earlier, it's really not necessarily only the attorney, it's the financial professional as well. If you want charitable, that could be a charitable advisor that helps advise you on what the most proper ways of distributing assets could be, or even helps you discern what charities are important to you and important to your family. Having conversations with your family about why you are doing the things you are doing is important as well. One of the things that I think Everence, and specifically one thing that I try and do is for a lot of folks that really are doing estate planning or doing, financial planning with us, we'll bring a family in and kind of be that third party to help discuss where things are at, what things look like. This is why we've decided to do this. So having communication with family is super important as well. And then finally, a pastor, talking through again the larger issues and the topics as well. So how do we get started? Well, there's four fundamental things as a starting point that you want to take a look at. Most of these can be done. Now, these four really should be done with an attorney. Some of them can be done online. I always recommend utilizing an attorney because you get the opportunity to develop a relationship with a professional there that you can ask questions on. But anyway, these are the four fundamental tools. Number one is a will. Number two is the durable power of attorney. Number three is a living will. And number four is a medical durable power of attorney. So we're going to dive into those a little bit deeper into each of those, but those are the four kind of starting points for your estate plan that you'll want to look at. So, what is a will? A will is a sensible provision, so it's usually pretty basic. There's usually not a lot to a will. A will could be, usually it is state specific, so you want to make sure, your attorney is familiar with the state that you're in. And I know we're kind of across the board with some of the states we're in. It basically gives your wishes and instructions. And it gives your wishes and instructions on a few different things. It could give your wishes and instructions that I want my watch to go to this person. I want this curio cabinet to go to this person. Um, I've seen wills that lay out a lot of different things. I've seen wills that are just super basic that say I all my assets go here. So you can make it as little or as in depth as you want that will to go. It gives the opportunity for bequests, and that may be bequests to a person, like I was saying with the watch, and also charitable gifts within the will. And then finally, I've seen some wills where especially if you know if there's going to be a reading of the will where there's a statement of faith and values there. We've seen where folks will make like a last statement as here's what I believe, here's why I believe it. And so that's been kind of neat to see as well. Now, one thing I'll point out there, you can see on the slide that there's two little asterisks next to the charitable gifts there. That's so I don't forget to mention this. A lot of times, not all the time, not 100% of the time, but a lot of cases, your will is not the best place to leave to charity. And we'll talk through that in a little bit as that is the case. But that is major misnomers or misconceptions that I see a lot is folks will name, biblical tithing 10%. In Mennonite circles, we like to leave charity as another child. So for me, it would be 3, 25, 25, 25, and we're going to leave charity as another 20, 25% beneficiary. A lot of times it's not the best place to do that in the will, but I see it a lot. So just something to think about, and we'll talk about some of the reasons here in a little bit. What are the advantages and disadvantages to a will? Well, the number one advantage is it's inexpensive. You literally could go do a will online at LegalZoom or any of the different websites, a basic will for pretty cheap. You can even go to an attorney. Every place is going to be different again, depending on cost of living and things like that. But I know here in Northern Indiana, most of the attorneys here will do all four of those documents, those starting point documents, for anywhere from $500 to $750. So it compared to other estate planning, things like trusts and things like that, it is relatively inexpensive. It's easily updated. You can go update the will at any time. You can create an amendment to the will at any time. And basically, the newest one that's on file, the newest one that is there, is the one that is in effect. A will is only effective at death, so kind of self-explanatory there, but a will is really only applicable at your death, and it's a simple starting point for many people. What is the disadvantage of a will? Well, number one, you've got to go through probate. So probate is state specific. It's different in every state, but it's basically the reading of the will and the distribution of assets. So the executor would go file the will with the probate court. It would, and it would go through the process. There's a couple different disadvantages that would come with probate. Number one is there's usually some sort of settlement cost, and that can range anywhere from 1% to a couple percent, depending on the size of the estate. It becomes public document, so someone could literally read all of your assets. Now, I don't know that you really care at that point, but it would have the ability to be public knowledge. And then the final one there is it, and probably the most important, is it doesn't allow for uninterrupted continuity, meaning there's usually a time process there for the probate estate to be settled. And usually, depending on how things are set up, there may be some assets that are frozen while it's going through the probate process. So at the end of the day, where can assets go? Number one, if I polled most of you, number one would say yes, important. Family members. If something happens to us tonight, we want assets to go to our children, our heirs, our nieces, nephews, any family member. Number two, we want it to go to taxes. And number three, we want it to go to charities. Now, if I had to do a poll here, most people on the call would probably say that taxes would probably be the least one that they want it to go to. We'd rather see it go to the two on the sides. And so, one of the things that you can do is you can really strategize to make sure that the as much as possible. Now, most people have no problem paying their fair share in taxes, but it does allow you to strategize which is the most efficient way to get to either family members or charity, whichever are your wishes most of all. Speaking of taxes, a lot of people think, oh, there's a huge, I'm going to pay inheritance taxes. Now, federally speaking, right now, the federal estate tax exclusion, meaning that if your estate is below this amount, you don't have any type of federal estate taxes on it, is 13.9 million. Now, there's some sunset provisions, and the tax laws are forever changing on that end. If a married couple, it's 27.22 million. So again, I'm not going to raise hands on the call if we have issues with that, but that's usually for most folks a pretty big number. Now, this is different than income tax. So we're going to talk about income tax on the next slide. But a lot of people, when I'm talking through estate planning topics, that kind of all intermingles together. Inheritance tax, federal estate tax and income tax are two different things. And then finally, some states, depending on where you're at, may have state inheritance taxes, and that ranges across the board. I know in Indiana, we don't have any type of state inheritance tax, but I've seen some have $100,000 exclusion, some have $1 million exclusion, and it really just ranges across the board. Now, I mentioned income taxes at death. Um, there's really, you can kind of categorize this into three areas of what is and is not taxable and how those work at your death. So I'm going to speak to the first one, which is taxable as ordinary income to beneficiaries. Those would be what a lot of us have: IRAs, 401ks, 403bs, any type of retirement account outside of Roth IRAs. Now, what would happen with that is, it depends on whether it's going to a spouse or whether it's going to a next generation. So, a spouse, if something happens to Craig and Missy, if something happens to Craig and it goes to Missy, she is going to inherit that IRA or that 401k. So it's going to go right to her. Okay. She would not pay taxes on that money when it goes to her. It's a spousal transfer, it's a non-taxable event. Now, she may still have to take distributions depending on her age and your required minimum distributions, but it's not going to be taxable when it goes to a spouse. When it goes to the next generation is where things get interesting and a little bit more complex. It used to be that if it were going to a child or another heir, they could actually take distributions most of the time over their life expectancy. So they could inherit this IRA, it would go into a beneficiary IRA, and they could take small distributions over their life expectancy. That has changed as of the Secure Act in 2020. Now they have 10 years to distribute that account. So, for example, if something would happen to my parents, I would inherit a $100,000 IRA from my parents. I now have a couple different options. Number one is I could just say, all right, I'll pay the taxes, give me my money. I send me a check and I'll pay whatever taxes are due. That would be taxable as ordinary income to me. I could also say I want to distribute that over a 10-year period. I'm gonna try and equal it out as much as possible and take that money over a 10-year period. Most people, that's the option that they choose. Or I could say, you know what, I'm not going to do anything. I'm going to distribute it on the last day over that 10-year period. Now, what's wrong, what's the potential issue between the last day and the first day is you could have a very high tax liability because it's counts as ordinary income. It's gonna be added to your income. Okay. But that's kind of the options that most people have. Stepped up cost basis at death is the second one, and that would be things like real estate, investment accounts that really don't have that retirement account shell under it, bank accounts. Those would typically get a stepped up cost basis. What does that mean? That means that for most things in most cases, if I inherited a $100,000 house or a $100,000 real estate, I won't pay taxes on anything, any gains there from an income tax or from a capital gains tax standpoint. There would be a date of death valuation, and I would only pay taxes on the gains going forward from that date. So it is a little bit more of a benefit to your beneficiaries to receive those assets as opposed to IRA assets. And then the third one there is not taxable. Those are things like life insurance, Roth IRAs. Those would go essentially tax-free to your beneficiaries as well. They're the most beneficial things to give to beneficiaries as well. Now, the Roth IRA, just an important note, the Roth IRA would be subject to that 10-year rule as well. Okay, so you can either take the 10, you can take the distribution now, not pay taxes on it. You can let it grow for that 10-year period and then not pay taxes on it, or you can distribute it however you want over that 10 years. This is a critical piece when it comes to what assets should be going where throughout an estate plan, especially if charity comes into play. So I'm going to show you just a quick illustration. I won't spend a ton of time on here. This is the Snyder family. They have an IRA, which is what a lot of us have anymore because we've saved through our employers. We have an IRA. The Snyder family has an IRA balance of 250,000. Here's what they think is going to happen. They actually have an IRA of 250 and they have a bank balance of 250. Those three, they left both of those. They made the estate, their will, essentially the beneficiary of those accounts. Both of those would get paid to the estate. Charity would get 250 and their daughter would get 250. It would filter through the estate probate process and everyone would get 250. What actually would happen? The IRA, the bank account balance would go to the estate. Whoop, didn't want to do that. There we go. There would be a 24% estimated tax rate bracket on that. The IRS would get 60, charity would get 220, and their daughter would get 220. Because again, the estate would pay the taxes as those assets get distributed. Okay. Let's look at another option. And this is one that we use a lot. What if we named the charity as the beneficiary of the IRA? So we didn't filter it through the estate. We named the charity RCA as the whole balance of that IRA. That would go directly without going through probate. Nobody pays taxes on that. That would go directly to the charity as 250,000. The bank balance would filter through. Remember, we get a stepped up cost basis at the date of death value. They value it on that date of death. The daughter would get 250,000 and the IRS would not get anything from that distribution. By making one small change and one small beneficiary designation, which essentially is the same thing, but doing it out of the IRA, it allows everything to go much, much smoother. What are some other estate considerations? Number one, I want you to be familiar with two terms. Number one is TOD or transfer on death, and the second one is POD or payable on death. Those essentially mean the same things. It really just depends on what state you're in and whether it's a bank account or an investment account. Basically, those take the real estate, the bank accounts, the investment accounts that aren't retirement accounts, and names a beneficiary on them. So it's usually a single form. If I'm with Everence Credit Union, I call up Everence Credit Union and I say, hey, I want to change my savings and my checking over to a POD, payable on death. It's a form they send me. I fill it out. I name my beneficiaries on that form. send it back in. Now that does not go through the probate estate. It doesn't go through the will because I've named beneficiaries on it. So it avoids any type of probate estate on that asset. Um, you could change a deed for your real estate. Let's say my home here in Goshen, I could fill out a form through the county, take it down to get it notarized, take it down to the county courthouse, pay a fee. The deed would get changed over from joint with Craig and Missy to joint with Craig and Missy TOD, transfer on death. Now I've named a beneficiary on that account. My house now does not transfer through the will, it transfers through the beneficiary on the TOD. Okay. If we do everything correct and we name life insurance, retirement accounts, and TOD, POD on everything that we possibly can, for most people in most cases, there isn't even a probate estate opened up. Okay. The personal assets in most states, it's a $50,000 limit to not having to open up a probate estate. And most things fall under that if we name it right. So, what's the takeaway here? There are things that you can do now that you should not have to really. The will would matter, certainly, because it has those other provisions. But from an asset standpoint, for most people, we can do a lot of stuff outside of the will. Okay. Let's switch gears a little bit, go to the durable power of attorney. This is the second one of the key things that you'll want to do. Durable power of attorney, think of financial assets. Think of financial assets only. These things, a durable power of attorney would include powers such as bill paying, banking, purchases and transactions, calling up to Craig to find out what a balance on your investment account is. Um, it's important for a couple different things. It's important for your banks, if you do a durable power of attorney, banks, financial advisors, people that may do some financial transactions, it's important to do. What they do not include is a power of attorney can't do a will for you or take away a will or execute a living will. So doing any of other legal documents really don't apply. There are some important considerations. One, I can do it now or later. So I can empower someone now. In that case, it may be um, an elderly person that wants to have a son or daughter be able to help them with their banking or help them with their investment accounts. Or I can empower somebody later to say, if something were to happen to me and I would be incapacitated and can't communicate for myself, then I want to have someone take over and do those financial decisions for me. The second consideration there is it terminates at death. It goes away. What happens then? The will, TOD, POD, beneficiary designations take precedent there. Third thing is a living will. This was popularized, gosh, 30 years ago, maybe. If you remember, there was a case with her name was Terry Schiavo in Florida. She got in an accident, wasn't able to communicate for herself. The husband was fighting with the parents as far as who made the decisions and what her wishes were. And so this basically outlines wishes in the event of a terminal medical condition, coma, or non-responsive condition. It was a little iffy back in the day when these first started getting popular, but now pretty much all 50 states recognize them. It's life-sustaining issues, and it allows your doctors to be the decision makers there. You could go, like I know in Indiana, you could go to the Indiana Department of Health and go fill out a living will. I know a lot of hospitals now, if you go in for surgery, they have you fill out a living will there as well. So again, you can do it on your own. If you're going to an attorney getting a will and a power of attorney, this is something that is often included in that, and it's usually not very expensive to include it. And then the final one is the medical power of attorney. So that would deal with all medical issues. It gives the decision making to the family, and it generally overrides the living will. So that's it's basically naming a power of attorney to come in and make medical decisions and get information for you. So a couple things, I had mentioned this a little bit earlier, stewardship estate planning. Kind of in the discerning, and if you remember the little steps that we talked about in the discerning and meditating piece, some important questions that I'll throw out to you. It's one that I've wrestled with a lot of clients over the years. How much is enough for children? How much, what type of impact do you want to have on your children with your assets if something were to happen? When is it too early or too late to leave money to children? So this gets back a little bit towards that ACE. We want to align our values with our financial decisions. We want to give confidence, and then when we have that confidence, maybe we want to give money to our children now. Maybe we want to help support them while they may need it more so than through our estate plan when they may not need it and they may be doing just fine financially. The third one there, what's the best way to leave a gift to charity? I hope you kind of got a semblance of that a lot of times it is not through the will. There's so many different options on ways that we can give to charity, which is way more effective. And then the fourth one is, have I planned for my incapacity? So do I have my durable and medical power of attorney and living will? Just a couple other, thoughts I'll have there is how much to give to charity. You could give a fixed amount. You could say, I want to do a X amount of dollars to this charity through my estate plan or through my IRA, probably. A fixed percentage gets back to that option or idea that I talked about a little bit earlier of charity as a child or the biblical kind of principle there, adopting charity, or I can give a residual bequest. I want to make sure that I give almost an endowment or something like that. And again, there's a ton of creative ways that you could do that as well. I want to hit kind of on a fifth topic that Billy and I talked a little bit earlier, and there were a lot of questions on this from the feedback for the seminar. What is a revocable living trust? And I want you to think of a revocable living trust as a bucket. Now, in that bucket, we're going to place our assets. Okay, so we can place most of our assets inside that bucket. I, as the trustee, who is kind of the decision maker of the revocable living trust, hold the bucket. So I can make decisions on the bucket. I can take the bucket away if I want to. I can change beneficiaries or provisions that you can think of are written outside the bucket that my kids are the beneficiary, that charity is gets X amount of this trust. So I have a lot of flexibility and a lot of control on that bucket and the assets that are placed inside the bucket. What are the advantages? Well, number one of a revocable living trust is you have probate avoidance. So you don't go through the probate process. The second one is it gives you privacy. And the third one is it gives you control. So essentially, it takes over the disadvantages of the will, okay, is one of the reasons we would do a revocable living trust. What are the disadvantages of a RLT? Number one is it's more expensive. It depends how much, again, where you're at and how much stuff you're transferring in there, but I've seen them maybe $1,500 to $2,000 for a revocable living trust. You also have to transfer ownership. So you actually have to put assets in the bucket to have the revocable living trust really help, or you have to do some other things. The one thing I will submit for most cases is the transfer on death registration replacing the need for a revocable living trust. So in a lot of pretty common cases, common assets, those types of things, I think we can do a lot with the TOD to replace the advantages of the revocable living trust and not have some of the disadvantages. Where would a revocable living trust still be applicable? It could be easier if you have property in different states. So if I have Indiana and if I had one, I had my lake or property, ocean property in Florida, and I had some farmland in Illinois, having a revocable living trust to kind of put all those assets in one bucket as opposed to different states could be helpful. Maybe I have a child that's a spendthrift and I know they would have serious issues controlling assets if they receive something. Or I wanted to do, maybe I had maybe a special needs child or something like that. There are things that the revocable living trust is still crucial for, but it's not always the thing that we think of as far as avoiding probate. Let's see. So I'm going to throw out just a few to finish up. I'm going to throw out just a few ideas from a charitable standpoint and things that I hope you know about these, but if not, I just wanted to throw out a couple ideas or a couple things that I see work really, really well. The first one is going to be a donor advised fund. If you haven't heard of a donor advised fund, think of a charitable checking account. Now, there's a lot of reasons that you would use a donor advised fund, but one of the most common ones is it allows you to give different assets to the donor advised fund and get some tax benefits on it. So you can see number one, we gift cash, stocks, bonds, commodities, or other assets to the donor advised fund. Gets placed in this charitable checking account. Because of that gift, we receive an income tax deduction off that gift, the same way you would give if you wrote a check to your local church. Then we basically can get from the donor advised fund, you can basically go on 24/7 and recommend distributions to charities of your choice. So I can go on and say, send $200 to this charity, $400 to this charity, $1,000 to this charity. What's the benefit? Well, one benefit is, let's say I purchased Apple stock 30 years ago. What would have happened to that stock? It would have done really, really well. Now, if I sold that stock and gave the proceeds to charity, I would have to pay gains on that stock, probably pretty significant in certain cases. But if I give it all to the donor advised fund, it gets placed in that charitable checking account. I can give it to any charity I want, and I don't pay capital gains on that gift. So as opposed to selling it, receiving cash, and writing a check, this is a lot of times the most creative way to do it. We have people give, let's see, we've had people give grain, commodities. We've had people give puppies, emus, quilts, maple syrup. You can give anything of value to it. Baseball cards, near and dear to my heart. You can give value, anything of appreciated value. For the most part, you can do in a donor advised fund and avoid the capital gains. Just makes a really, really good way of giving for a lot of people that may have some appreciated assets. I'm gonna let me see. I'm gonna skip through here. So where do you begin? Because I'm running past my time on where what I committed here. Where do you begin? Number one, prepare an asset summary. Figure out where your assets are at. Do that meditation and discernment process. Define what do you want to have happen here? What is the right place for you if something were to happen? What would you want those wishes to be? And then coordinate with your estate plan, with your financial professional, your tax professional, and attorney. So use a quarterback approach, get a bunch of different looks at it, and really determine what is the best course of action to implement what you're hoping to implement. Again, for a lot of folks, there are strategies that you can implement that are going to make it way easier for your beneficiaries, for charities if you want that, or for your executor to make sure those assets get to where you want to go. I'm going to pause there or stop there. I know I went through a lot of information really, really quick for 2 p.m. But is there any questions that anyone has? I'd say feel free to unmute and ask any questions that you may have.
Great. I'm going to give folks the opportunity to
Okay.
unmute themselves. Okay, they now have that capability. So that's out there. Feel free to chat it in and I'll monitor that and share that with Craig also. Yeah, do we have any that you'd like to lift up?
I have a question. Can you hear me?
Yep.
Yes.
Okay, great. Um, I wanted to ask a couple of questions. This was very helpful because prior to today, I had really thought that a living trust was probably the way to go, but it sounds like it's not really necessary unless you have certain things because
Yep.
you can accomplish the same types of things in avoiding probate with well, with having beneficiaries, obviously, but also this transfer on death or the payable on death certificates. So I'm wondering a couple of things. First, um, you mentioned that also with like changing the deed. So using the deed to your house would be a good place to use that. Are there other like kind of normal or general places that you can suggest for that that are not, too out of the ordinary?
I mean, not really. So if I'm going to go back to one of my slides here, uh,
That was really the only one I could think of in my situation that where I would use that. I think most everything else. I do have another question about just general bank account balances, but
yeah, yeah. So I mean, I think if we go back to this slide, which is I think one of the more helpful when we're discussing like what that would look like.
yes. Yep.
For most people, three-quarters of the people that I see, I would say, most of the assets are in a 401k, IRA, things like that, or the house. Like
Yep.
there's, maybe a car, but a car is a depreciating asset. So for most people, number one, make sure 100% all beneficiaries on your IRAs or 401ks. It's a hot mess if you don't. So that would be my first thought. Just I don't know that I mentioned that. But for most people, they've got that covered, right? So they've got their beneficiaries there. If they go change the home, which, it, it is a process. So it does require, I don't remember what the cost was. I think it was a couple $100 maybe to change the deed to reflect a TOD. I know everybody's in different states. Most states you can do TOD on your real estate anymore. So it's really just changing, and if not, Google it. I Googled Michigan just because I know there would be a lot from Michigan there. There's a checklist literally for Michigan of everything that you need to fill out, what the form is, and take it in and do it. Bank accounts, I would say, like I don't have a TOD on my checking account, just because I don't keep a ton in my checking account. It's more of a working account, but you want to make sure like if you have any significant assets in your savings account, it does no harm to have a TOD on your or a POD on your savings account, regardless of the balance. And then now the life insurance and Roth IRAs, most you name beneficiaries on those. So yeah, literally for most cases, if you do the legwork up front and make sure all of those things are covered, I've seen a ton of places where, a husband and wife eventually maybe not together, but would pass away and it would go to the next generation. And if we've done the pre-work before that, the executor literally just goes, you file the will, but you sign a affidavit for a small estate affidavit, which in most states is 50 grand, and then it's done. So, I mean, I think real estate and the retirement accounts are the main ones for a lot of people,
Okay. And filing a TOD is pretty straightforward, pretty easy.
especially with the bank accounts and the investment accounts. Like literally, you
Okay.
could probably go online to your bank and probably pull off that form right now.
Okay. And all of that having beneficiaries and a TOD on basically, I mean, you mentioned like preparing an asset summary, making sure, but that alleviates anything from getting stuck in probate.
Correct.
Great. Thank you.
It looks like Craig Hoffman unmuted. Craig, do you
Yep.
have
Go
a
ahead, Craig.
question?
Nice
Yeah,
name.
I just wonder, are we able with our Fidelity church accounts and Fidelity 403B accounts, are we able to do, if I die, all the money goes to Jan. If she dies, all her for the Fidelity money goes to me. Are we able to do that next generation down with Fidelity as well, so that if both of us die, we can designate our kids?
Yeah,
Yes.
absolutely, and you should.
Okay, I'll make sure. I think we have, but I'll make sure.
Yep.
Yeah, I would be as specific as possible with that, Craig, too. Like on those beneficiary designations, like I'm guessing Fidelity asks for birth date, social security number. I don't know that for sure. Um, but yeah, I would anything you want to go. essentially when you go in there, you would name your spouse as the primary beneficiary,
Right.
and then there would be usually there's a check down or a separate space there for a contingent beneficiary.
Okay.
And you can name as many contingent beneficiaries as you want. Sometimes the system limitations may not let you name 15 or whatever, but yeah, you so name each of those as much as you possible, and the percentages that you want each of those to get as well.
Okay. Good.
Yeah.
Thank you.
Craig, I'll add to that. So you
Perfect.
can do that two ways. You can use Fidelity's call center, or even better, go into netbenefits.com, access your account, and you can check your beneficiaries, change it, add to it. And yeah, you can do percentages, just as Craig mentioned. But one of the things I would recommend is to add those social security numbers. There is a spot for that with the beneficiaries, and it makes the process of transferring those funds and getting the beneficiary account set up so much quicker and easier for your beneficiaries. So, accurate address information, social security numbers, have that ready to go, and it's out of love for the people that you want this money to go to. So, highly
Okay.
recommend it and do it regularly.
Good.
Yeah.
Thank you.
Thanks, Billy.
Yeah. It's I've had a few, not something that we set up. I've had a few people pass away without a secondary beneficiary named. And essentially what happens is it goes through the probate estate. So it would filter through the will. But the estate has to pay taxes on it too. So, and usually estate tax rates are a lot higher than individual tax rates, depending on the state. So it it's 100% easier. Now that you don't even have to sign a form, I would imagine, Billy, I know a lot of them, you don't have to sign a form. So you literally just click submit and you're done.
Great. I'll make sure. Thank you.
Billy, did we answer all? I think the only other question I had, wasn't there a long-term care question or something on one of the,
I'm not sure. I did
oh,
get a message in from one of our participants that
okay.
says, on retirement, is it better to start taking money from Roth or IRA?
Ooh, good question. A lot of schools of thought there. I'll answer it in a couple different ways. So one of the most popular things it depends on when you retire, I think is the first answer, right? So one of the most popular things that we're doing now is, let's say someone retires, but they retire at 65, and I'm just throwing that number out there just for lack of a better number. They retire at 65, they've got a lot in IRA, which is what I typically see. They've got a lot in pre-tax and not as much in Roth. Between 65 and when you start taking your required distributions, which is 73 for most people right now. So at 73, you have to start taking distributions out of your retirement accounts, but at 65, you don't. So one thing that we're doing a lot of now is trying to convert assets from IRA to Roth IRA to get it at a lower tax level because a lot of your income has gone away. So I would say don't diminish that strategy and talk to a professional, especially, or make sure your professional is looking at that to see if that's a benefit. In most cases, back to the question at hand, in most cases, I like to leave the Roth IRA to be the last possible asset that is spent. It's up to the individual situation and what the goal of the estate is. But for most people, their goal is, I would rather pay taxes now than my kids having to pay taxes down the road. And that's not everybody is like that. Everything's individual. We could talk through that. But for most people, I will say they tend to let that Roth IRA grow as long as possible and not take distributions. A Roth IRA is the most flexible possible thing you could get from an investment standpoint, especially going to your beneficiaries. Because literally, if I retire at 65 and I live till 90, that's 25 years of growth. Yes, I would have paid taxes on IRA distributions as I went, but that's 25 years of growth, and my kids can keep it another 10 years tax free, and then have no taxes paid on it. So if that's the goal, then I would say the Roth is the best way to go. There are some scenarios in which if you're trying to slide under a certain tax bracket, taking a little bit of a Roth distribution could be helpful too.
Thanks. And while we're on that, Craig, just if you could just briefly maybe add a note about the clergy housing allowance and how that might fit into the strategy.
Yeah, certainly. So clergy housing allowance is a absolute huge game-changing benefit for a lot of pastors. So if you are a pastor, and you've contributed to the RCA plan while you've been a licensed pastor, the IRS says that you can take your distributions from your RCA plan and categorize it as housing allowance the same way you did with income when you were a pastor. So, if you have $30,000 in housing allowance while you're a pastor, and I'm just throwing that number out there, you can take a $30,000 distribution in retirement out of that RCA plan and do the same exact thing, making it non-taxable from your income. That has a big difference, certainly on Roth versus pre-tax, but I don't even consider that pre-tax if you can use it for housing allowance. The one main catch there that you want to make sure no other financial advisor ever talks you out of: when you retire, you must keep the assets in the RCA plan. You cannot roll them over to an IRA, or you lose the ability to categorize that as housing allowance. So you want to just make sure that, when you would retire, those assets need to stay there in order to be able to categorize it as housing allowance from a distribution standpoint. So you just want to make sure you keep them there. Most most advisors don't do it on purpose. They just don't know the rules when it comes to clergy distributions from as housing allowance. And that goes away if you pass away and it goes to a spouse. So like Craig, in your example, if you were a pastor and it would go to you would have a spouse as a primary beneficiary, that housing allowance option goes away for that remaining spouse.
Thank you so much, Craig. We are almost at the top of the hour here. Any final parting thoughts or pieces of wisdom that you want to share before we wrap up?
No, I will. Let me, if I can get there. It Billy knows how to reach me, but I just wanted to give you my contact information if for some reason you had a question that came up after this. Um, Feel free to email me if you have any other questions, or reach out to Billy, certainly, and Billy can get you in touch with me as well. If you are a pastor on the call and you haven't done financial planning with an Everence representative, they have a RCA. Billy can answer those questions as well. There's a great benefit to do financial planning with Everence as well. So, yeah. But
Thank
thank you for your time. I appreciate it.
Thank you so much, Craig. I was just responding to one more chat from a participant. That's why I'm moderately distracted, but I want to say thank you. This is such a valuable resource to us, to our participants, and for anybody in our circles that we can share this information with. This applies to everybody, and this knowledge will hopefully bless us and bless those we talk to. So thank you so much. And like Craig said, feel free to contact him, contact me if you need to get to Craig, and let us know what else we can do for you. But thank you for joining us and have a nice day.